It has been one of the biggest controversies over the last week. It started with a statement by the Attorney General's office, and that sparked a storm. And so we said, okay, on the back of the latest press conference address by the Attorney General himself to add a bit more meat to his earlier, very brief press statement, we said, okay, let's do a bit of digging. And this is a story that we covered quite extensively at the time it was happening in between 2017, 2018. And a lot of the facts have become pretty hazy. And so we need to track that and understand where we are currently and why we are where we are, but also understanding what really are the resolutions and what are the various parties' role in trying to come to a conclusion that is ultimately beneficial to this country. One of the first things we noticed as we began to pore over the court documents that we've applied for, that we secured, and additional documentation, including the very original KPMG report on this matter, is that there was initially a lot of confusion about how much exactly was involved here. And once I go through that, you understand why the Attorney General has arrived at where he has arrived at now, with a significantly reduced amount. The first big figure that we saw was 4.97 billion. And this was a figure that was pegged by at the time, the administrator who had been appointed May 31st, 2018, right? And remember, the administrator then transitioned to become the receiver. So same person, right, doing the job. And the first thing they did, the KPMG identified 4.97 billion. And then they did some further work. And the 4.97 billion quickly then became, and this, by the way, was 31st May 2018. That amount then quickly becomes 5.7 billion. That is the amount that you've heard a lot about. But that is not where it started. It started with 4.97 billion, and then came to 5.7 billion. Now, we're asking ourselves, so what really was happening at the time? This was all happening in 2018. What really was happening while we had these changing numbers? And then we discovered, just pulling back again from the archives, that document from KPMG, the reason why. Because we saw very, very quickly from the KPMG's own administrator at the time, Niamano Dodu, admitting something very fundamental. He says, we have not sought to verify information or perform procedures necessary to express an audit opinion on any financial or non-financial information contained in this report. So they haven't done any verification at the time. And it took quite a while for them to sort of come to terms with what really was happening at the time. In fact, it took years. And I'll illustrate pretty shortly. From 2018, only 2024, last year, before he came to a settled figure, or what appears to be a settled figure. Just pause for a second. 2018, 2024. We'll come to that 2024 figure pretty shortly. But he admits in that very original first KPMG report that really formed the basis of the revocation and all that, a fundamental caveat, which is that they haven't sought to verify information or perform procedures necessary to express an audit opinion on or financial or non-financial information contained in this report. And then it didn't stop there. It makes another disclaimer, again, trying to get you to understand why he can't be certain about any figure. It says, accordingly, we are unable to determine the extent to which information provided, of course, to them, are complete and accurate, and the report should be read in that context. And that is very important. The question that you need to ask yourself is, did the decision makers at the time, the finance ministers, read this document and take the actions within this context that a lot was not verified? We'll come to another opinion as rendered by Godfrey Dame himself. That also explains this question I'm asking. But a big question that we asked when we saw this, because we also saw the changing numbers, was, okay, so if you haven't verified, how did you first start at 4.97 and then end at 5.7? When clearly from your own admissions in the audit report, nothing has been verified. So that is really the genesis of the problem with this Unibank issue. That is the genesis of the problem. And then as we go through, you understand why once you start off with this, you then begin to get a bit conflicting with the numbers and how to resolve it and who is going to pay what. So first understand this background. But really, for those who wanted to sort of catch up on why really this became an issue, three things really. The accusations then of the liquidity and solvency, they claimed that unmet payment obligations and also misuse of liquidity support, where broadly the accusations that were leveled against the shareholders of Unibank. Now, a few additional things that we also found was fascinating. Shortly after all this began to happen, and they wrote to the shareholders and the directors of the bank, the shareholder did something fascinating. And they were writing to, and this was on the 5th of June, they're writing back, right, where the 5th of June, 2018, committing at the time to inject $1 billion by mid-July. So between 5th of June when they were notified, they said, well, by mid of June, we can give $1 billion back to get the bank on the path to recovery. $1 billion first. So shortly within a month, they were willing to give $1 billion. And then second, they again wanted to inject another $1 billion before September. In other words, in 2 months, they would have put in $2 billion in 2 months from June 5th, 2018. $2 billion. Now, keep that figure in mind, $2 billion. This is 2018 we are talking about. When a shareholder says, we can save this bank, allow us, give us 2 months, we'll provide you $2 billion, put it back in the bank, and let the bank run. Keep this figure in head, because I'll come back to it. It will make sense pretty shortly why this figure $2 billion is key. But that's what they committed to do at the time, right? That they wanted to save the bank, and they have money to put in, and will do it in 2 months. Very important figure. And then they said, there's also $3.7 billion in assets that we can also make available, all to save the bank. But for me, one other thing that was striking in this letter that they wrote was that the government of Ghana owed them huge amounts. In fact, contractors owe them huge amounts. The government of Ghana itself and contractors who have also taken loan from the Unibank and were doing government projects owe them amount. And they asked the BOG and the government of Ghana to settle what they are owed, which is around $1 billion. Settle that debt to us. If you do that, and we give you $2 billion here, plus this $1 billion, that's $3 billion. Remember what the administrator was asking for? $5.7 billion thereabout, right? So that's $3 billion already that you have back in the system. And this is on record, part of the court documents that had been tendered in. Now, other thing that again was fascinating, right? And changing numbers, pay attention to that. We know that Unibank assets with government at the time so exposed to government to the tune of $3.1 billion. So, and this goes to answer the question. So all the monies that we're talking about, that we heard about, that the allegation was that had been looted, the huge chunk of that, where were those monies? Were they really looted? And you listen to the Attorney General say that, well, no money was really looted. A lot of that was with government itself. Let's break that down. A total of $3.1 billion. And this is all part of the document before the courts, right? So you can apply and get the details there. And let's break it down. This $3.1 billion, again, tracking the money, follow the money. T-bills alone came in at $1.1 billion. You had ESLA bond at $131 billion. Then you have cash and short-term funds of $233 billion. Unpaid guarantees, IPCs, and for me, that is a huge one, $1.3 billion. This is the exposure to government. Government itself owed them so much, $1.3 billion. That's unpaid guarantees. Simply put, this is the Unibank exposure to government. Government debt with them, the projects that they had funded sometimes, the contractors, all that put together, $1.3 billion, plus, of course, the bonds, the T-bills, etc., right? And then you have others. You have the GOG guaranteed loans. GOG guaranteed loans of $457 million. Public institution loans, right, of $46 million. You have export guaranteed loans of $114 million. And then you have the GOG mortgage loans of $9.3 million. In essence, that is a breakdown of where the money was at the time. And this is, again, before the courts. And you see the list here, all coming to a total of $1.3 billion, right? So this, again, is fascinating. And you need to ask yourself that question. If government had paid back part of this money, will the bank have probably survived or died. And questions were asked at the time, quite significantly, when this was happening. But because of everything that has happened, you need to trace back to understand why we are where we are. But that is where you find the bulk of the money in terms of the breakdown, right? Were things done, for example, that indeed were not best practice? Of course. And that is why you see that some of the shareholders still say we are offering to put in $1 billion, $2 billion. But because that's what the law allows. The law actually makes room for shareholders at the time when the bank is struggling to put money back in. It's in the law. In fact, Godfrey Dami mentions the list of things that the shareholders are allowed to do. Because the law anticipates that sometimes banks will struggle. The shareholders must cough up the money. And indeed, it said they can't produce and bring up the money to solve the problem. Now I'm coming back to helping you understand this initial confusion at the beginning when the administrator was not quite sure and had pegged the figure high north of $5 billion. As of March 2024, in fact, to be very specific, March 26th, the receiver is in court and has significantly revised the amount involved. Remember that. From $5 billion plus, the receiver in court just last year says he's no longer interested in $5 billion because he's now looked at the books and everything else that happened at Unibank, and it is significantly less. In fact, it is $2.8 billion. This is on the court document. That's how much he says the liabilities are. And that is how much he says now the shareholders and the defendants in the case that had not been discontinued must pay. See the huge drop. This is the receiver now. The same person was the administrator who then transitioned to a receiver, right? Now saying it is not $5 billion anymore. It is $2.8 billion before the court. And that is fascinating for me, right? Clearly tells you that the premise of the case against Unibank at the time was fundamentally flawed because the man himself who is leading the thing, the receiver, had come down to 2.8. And once you see numbers changing as consistently as it has, as I've illustrated, then it says you may not be on solid ground. And that possibly may explain something the Attorney General said. Is that if we pursue this matter further, we may not be in a position to win it because you can show the evidence. But then there's also the case of what the previous government's own Attorney General at the time said. So from $5 billion, same person, the receiver, is now just last year telling the court it is now $2.8 billion. So what happened to the difference? And remember, it didn't even start at $5 billion. That's $4 billion. $5 billion, now $2.8 billion. So which figure are you working with is a fundamental question. But you find the answer in the KPMG report, which was in essence saying we haven't verified. And now a lot of verification is happening over time. But also pay attention to 2.8. It will add up really shortly when you begin to look at the Attorney General's press statement and press conference. I will illustrate pretty shortly. So this is the Attorney General recently now telling us that, well, we have now negotiated this, having taken over and looked at the matter and having actually asked the receiver itself to do reconciliation with the BOG and talking also to the shareholders of Unibank, we've come down now to $3.3 billion. And remember, $3.3 billion out of court, it is far more than the receiver who is taxed primarily, who is trying the case, but it is the receiver versus the other defendants. He himself is asking for $2.8 billion. But when they negotiated this with the Attorney General, they are talking about $3.3 billion, the $3.3 billion CDs. But the breakdown is what fascinates me because you see that it will come back to $2.8 billion. Just follow. The Attorney General then tells us, in terms of the revision, right? If you look at, so how did they come to from the $5 billion? The Attorney General also is working at a $5 billion figure. How did they come down now to 3.3? They said there's $2.1 billion there. That is fictitious claims. This really didn't go to anybody's pocket. It was just added to the books. And so it's nothing there. It's poof, it's air, right? So you can discount that. So that's the first one they discounted. And there's $300 million, which is in a separate entity subject to a different state agency that isn't part of the Unibank issue. So you have to discount that too. So they took these two away and it came down to the $3.3 billion. So that is gone. Now, then comes the question about what the shareholders are now offering to pay. which is what the Attorney General said, the 60%, which is what has caused a controversy. 60%. Attorney General says the shareholders say they are ready to pay $2 billion in full of the 3.3. Pay attention to this. $2 billion in full of the 3.3. Now, if it's $2 billion, but the thing is 3.3, they are paying $2 billion in full, of course, then there's a bit more to pay. Then they say, in addition to the $2 billion that we're ready to pay, and now let me say something about the $2 billion, connecting to what I started, where I started. Remember that in 2018, Unibank said they were ready to pay $2 billion in 2 months. $1 billion by middle of July, and an additional $1 billion by end of September. $2 billion. 2018. In 2025, having negotiated, having brought the figure down, they've ended up same place. $2 billion in full is what Attorney General is telling us. So the key question you must ask when you do the linkage to the when they started, then the whole bank was collapsed, is fundamental. They offered $2 billion at the beginning in 2018. If we could do that and take the $2 billion to save the bank, why did we wait for 6 years to do what we should have done to save the bank at the time? That is a fundamental question. What really informed that decision? Because we are back there. It means that the shareholders are still willing. One thing they have kept and they are very consistent about is that regardless of the time difference, we are still committed. They haven't changed their commitment to the bank. They haven't changed it. $2 billion in 2018, $2 billion in 2015. They are still very committed and consistent with how much money they want to put it back in because of the way the bank was run and the challenges it faced. So that they have remained consistent about. And that for me is a fascinating trend, just connecting to different times and arriving at the same figure is fascinating indeed, right? So that's the first one. They are going to pay $2 billion in full. They would have paid $2 billion then, and Unibank would have been saved. As you know what happened, a lot of jobs was lost. People died as a result of that. I remember doing a lot of stories about the workers who now have lost their jobs and they were struggling. But money was available, at least if you chased the shareholders. They remain consistent. They haven't changed their word on this figure. 2018, $2 billion, we're ready to pay to keep the bank afloat. So you save depositors' funds. 2025, a different government, $2 billion same. But then another interesting, fascinating dimension to this is that the Attorney General said once they pay the $2 billion in full, they say they have $800 million in assets that are sure that they will give back. Now pay attention. I want to go back to another figure. This is the receiver's own figure now, the new figure before the court as of last year. Remember what I said? The receiver is now before the court, not asking for $5 billion, but asking for $2.8 billion. If they pay $2 billion in full and $800 million in assets, you put the two together, you land at $2.8 billion, which is really what is before the court too. So although the Attorney General may have negotiated this out of the court, somehow the figures are adding up and landing at what the receiver itself is asking for before the court. Again, fascinating indeed to see how this is playing out in terms of the numbers. Just follow the numbers, and it's fascinating. But one of the things that I also noticed, and I'm going to repeat, is the consistency of the shareholders in their commitment to then keeping the bank afloat and now also making restitution for what has happened. But then there's additional money that needs to come, and they said they're going to shortfall to be declared via asset sales, and then $2.2 billion to be recovered with cooperation. The shareholders are cooperating to retrieve others. And then you see the $500 million that has been recovered according to the AG, and then $700 million outstanding that will be retrieved over 18 months. Now, the fascinating bit of Godfrey Dame's opinion. That we know was written in 2019. And I thought that was really fascinating. The first thing I found there in that document, and this was a letter, an opinion to Ken Ofori-Atta on the Unibank matter. First thing that I found was fascinating. In June 2018, Unibank administration is notified that of this $868 million that they are owed, that is owed, right? So the Unibank notifies the administrator at the time, notifies they had been put in charge, notifies the government that you owe Unibank 868 million. That is what this is about, right? The government, you owe Unibank 868 million. So pay us that money. That was one of the fundamental jobs of the administrator at the time. But this was in June 2018. To be precise, this was on the 22nd June 2018, when the administrator, who had been put in charge of trying to run the bank, trying to save it, etc., wrote to the Bank of Ghana and the government and said, look, if this bank must survive, you owe us to pay 868 million. And remember how that amount of money is very close to what I told you about the breakdown. It was then, when I told you the breakdown was just over $1 billion. At the time, it was also very close to $1 billion too. This is 22nd June. Then on the 12th of July, the Finance Ministry acknowledges this. And remember, the administrator was appointed by government. And then the administrator is telling government, you owe the bank you put me in charge of, right? So make the payment. Finance Ministry acknowledges the letter and says we are validating and verifying this amount. This was 12th of July. Between 12th of July and the 1st of August, when the validation had not concluded, the government moves to revoke the license. And this throws up a very obvious question. If the administrator is saying, owe us money, pay, Finance Ministry acknowledges and says we are validating, do you wait to validate and see if you pay back what you owe the bank, you add a bit more to it, you can revive it? You don't wait for that to complete, and then a few weeks later, in fact, two weeks later, you revoke the license. Follow. I'll come to what Duffour and Unibank said quickly, but this is all in his opinion. And then on that same day, a few things interesting happened. I'll jump the 2nd August one. On that same day, a few things happened. First, they revoke. Same day they revoke, they create another bank on the same day called the CBG. Revoked on the same day, created on the same day, was given the universal license on the same day, and on the 2nd of August begins operation. All happening in 24 hours. It's virtually impossible. But then Duffour and Unibank, having looked at the details, concludes on something, says, quote, it is apparent that the revocation of the bank's license or appointment of a receiver are not actions permitted under a report prepared pursuant to section 114. In other words, jumping to revoke the license wasn't part of the options if you really wanted to deal with this struggle of the bank. You had to give the shareholders an opportunity to pay back monies. You have to possibly get another shareholder to come in and put money into the vehicle in the bank to make it run. Duffour and Unibank went through the list and says revocation is not part of the deal at the time. That was one of his conclusions. Another thing he said is that the transfer of the Unibank to CBG on August 1, 2018, breached the law, as CBG was not licensed to operate on that date. But it was working, it was doing business, what it was supposed to. And the thing that I found fascinating here is that it says it is a criminal offense for CBG to have been allowed to operate, to do business, when it had not been licensed to operate. And it was fascinating that their own Attorney General's department was saying to them at the time that what happened was fundamentally wrong. And it couldn't find anywhere in the law to support the actions that we're taking. That is the journey, and that's where we are with all these negotiations around who is paying what, 60%, 40%. But just to understand the dynamics of why this has traveled so far and why the numbers are what they are right now. One thing is consistent, as I said, the $2 billion that the shareholders say they will pay in 2018, that the government rejected and revoked, which the Attorney General says, again, was in breach of law, etc. The same amount they are ready to pay now. This government, the difference is that this government have accepted it. But after the bank had been collapsed, right? After the bank had been collapsed. That's the story. My guest will join me for analysis of this. So what are the implications? What lessons can we draw from this? And we have a financial economist joining us to break this down. Because whilst we have this conversation, we must learn lessons for the future. And then we'll look also at the legalities of this. So what does this really mean legally? Details after this.